Hi, I'm Eric France, a commercial disputes partner at UK national law firm Mills and Reeve. Today, I'm going to give you some quick pointers on force majeure clauses. There's a lot of interest in these kinds of contract clauses at the moment, given that they may have been triggered as a result of the pandemic. Force majeure clauses allow parties to escape liability if they can't perform the contract because of a force majeure event, as defined by the clause. Whether you're concerned about your own ability to perform a contract or worried about another party performing, it makes sense for you to do the following 5 things. First, review your key supply and other contracts to check whether or not they contain force majeure clauses. Typically, these look like a kind of shopping list of disaster events, followed by a catch-all phrase like, or any other cause beyond the party's reasonable control. Second, you should assess whether the coronavirus pandemic falls within the scope of the clause. If the clause specifically refers to epidemics or pandemics, then it most likely will. If not, then it may well depend on whether or not the clause contains a catch-all phrase and the scope of that catch-all phrase. Third, you need to consider what the clause says about the connection between the force majeure event and the reason for the party not being able to perform the contract. Some clauses might require that the force majeure event has prevented the party from responding. Others might have a lower standard, like it might be sufficient if the party has been hindered or delayed in performing the contract. This could be really important because there could well be a dispute between the parties about the real reason for a party not being able to perform the contract and whether it really is the pandemic or some other reason, like the party's poor financial position before the pandemic began, for example. Point 4 is that you need to consider whether the effect of the clause is to suspend the party's obligations for the period that the force majeure event is active, or whether it's to terminate the contract entirely going forwards. If it's a suspension clause, then the party will need to carry on performing the contract after the impact of the pandemic subsides. If it's a termination type clause, then there may well be a requirement for the party who wants to rely on the clause to serve some kind of notice under the clause, and there could well be a time limit for serving that notice. Finally, even if your contract doesn't contain a force majeure clause, then if one or other party is looking to get out of performing the contract, then they may be able to rely on other grounds. It's possible that the common law doctrine of frustration might apply, or one or other party may have the right to terminate the contract. I've left a link in the comments section below where you can find out more about these things. These are general points, and if you need specific advice about your circumstances, then you should consult a specialist contract disputes lawyer. My details and the details of the Mills and Reeve team are in the comment section below. That's all for today. Next time I'm going to be talking to Mark Davison, our new Head of International Arbitration at Majeure.